Apparently,
I'm not
Mr.
sure why that
Feifelsky, we're
is.
not hearing you.
Maybe
when you
there's a
speak.
disconnect
I'm not
between
sure
your
why
car
that is.
and your
maybe there's
audio,
a disconnect
sir,
between your
maybe?
car and your audio, sir, maybe. No, we can't hear you still. In case that's what you're asking, I'm not sure if that's what you're asking. In case that's what you're asking, I'm
Bluetooth.
not sure if that's what you're asking. Yeah, if you have Bluetooth,
Bluetooth.
disconnect your Bluetooth. Yeah, if you have Bluetooth, disconnect your Bluetooth, sir. All right, I'm gonna pass that and go backwards for a moment. I'll come right back to you. Pass that if your attorney gets this for a moment. I'll come right back to you if your attorney gets this. What would we call the case of Ypsilanti Township versus Ryan Brown? Case number 25 T 001 Township versus Ryan Brown.
Paul Barnett on
Case
behalf
number
of the
25 T
township.
001
Jonathan Jones on behalf
Paul
of
Barnett
Mr.
on
Brown.
behalf
Your
of
Honor,
the
thank
township.
you for the Jonathan Jones on behalf of Mr. Brown. Your Honor, thank you for the. He's going to plead guilty to at least one bond violation. He's going to plead guilty to at least one bond violation of missing a date, and he did in fact receive a phone call prepared to admit to that violation. So I'd like to take responsibility for that violation.
Are you saying that he's
take
gonna try to
responsibility
plead
for
to
it.
missing just one date? Saying that he's gonna try to
he's
plead
denying
to
that the
missing
other
just
ones
one
were-
date, and he's not that
he's
he's missed the
denying
other
that the
dates?
other ones were-
He's told me that he has
That he missed
been
the other
testing.
dates?
He's told me that he has been testing. There has been some sort of, that there may be a delay. I don't know how to phrase this, that there may be a delay in the results. But he does not acknowledge, but he does not acknowledge that that's his position. He absolutely is not listed. That's his position. He absolutely the staff called and spoke to him and then called back date. That the staff called and spoke to him and then called back.
What we're gonna do is I'm gonna adjourn the hearing. What we're gonna adjourn this date to September 8th. So you can look into that
this date
because, like I
September
said,
8th.
once you can look into that
Schedules
because,
this
like I
for-
said, once he
for a hearing,
then
schedules
and if he's
this
found
for-
guilty, it's gonna be
for
a
a
big
hearing
problem
then,
for him.
and
if he's found
I
guilty,
explained that to
it's
him.
gonna be a big
Yep.
problem for him.
I can't be there on the 8th.
explained that
As I
to
said, I have a capital trial.
I
can't be there on the 8th, as I said, I have
So
a capital
the
trial.
15th
and
work?
that day. Yeah, that's perfect. Whatever time works
So
for you on
the
the 15th, we'll be
15th
there.
work.
Yeah, that's
September
perfect. Whatever
15th at
time works for
9
you on the
a.m.
15th, we'll be there. Thank you. I'm sorry this was
September
such a trouble
15th
this
at
morning. I
9
know you're
a.m.
very busy. All right,
Do
thank
you
you. I'm
want-
sorry this was such
Do
a
you
trouble
want
this
me to
morning.
do
I
the
know you're
final
very busy.
settlement conference
Do
date
you want-
today as well?
do you
so you
want
can get
me
on
to
that
do the
calendar?
final
settlement
Yeah,
conference
that would
date
be perfect
today
if
as
we do
well,
that
so
on
you
the
can get on
15th
that
as well.
calendar.
Yeah,
No,
that would be
that's not
perfect
when
if
it
we
will
do that on
happen.
the 15th as
happen
well.
until October 31st.
No, that's not
Okay.
when it will happen.
Oh,
The way
okay.
they're
Setting
setting them,
October
it could be full by
31st.
then.
Okay,
So
yeah.
let's,
The way
Right.
that you want
setting them,
October
it could be full
31st.
by then. So
Thank you.
let's, at 9
We don't have
a.m.
to dress
October
up, do we?
31st
Thank you.
at 9.
We don't have to dress
What
up,
now?
do we? It's Halloween. We don't have to dress
What
up, do
now?
we?
No,
All
not
right.
that.
It's Halloween. We don't have to dress up, do we?
No, not
All
that.
right. But
Our
you
costumes
understand
can
why
be
I wanted
lawyers.
clarification.
Our costumes can be lawyers.
Paul, it's not a costume for you, but it is for me. Paul, it's not a costume
November
for you, but
7th
it is
at
for me.
8:30 a.m. for the
Right.
jury
November
selection.
7th
That one
is
is
in
in
person,
person,
so
so
everyone
one
should
should
plan
plan
on
on
it.
jury selection.
All right,
That
awesome.
one
Thank
is
you,
in
Your Honor.
person, so one should
Bond is
plan
Stay
on it.
safe. Thank you. Awesome. Thank you, Your Honor.
Thank you, Your Honor.
Bond is
Stay safe.
continued.
Thank you.
Sorry.
Thank you, Your
Thank you.
Honor.
Mr. Feifelsky, can you try to speak for me at this time? Thank you. Mr. Feifelsky, can you try to speak for me at this time? No, still can't hear you. No. Nope, still can't hear you. No. You should probably turn your car off and see if you can just do it through your phone. You should probably turn your car off. You have to turn the whole car off, open your car door. You have to turn the whole car off, open your car door. No, can't hear you. You did that. I'll pass it again. Oh, I never recalled it, but I'll pass it again. I'll try it again later. I never recalled it, but I'll try it again later. What's Mr. Mack here? Okay. The court call the case to the state, not yet, Mr. Mack. Okay. The court will call the case to the state, not yet, Mr. Mack. The court will call the case to the state of Michigan versus William Hudgens, case number 25. The state of Michigan versus William Hudgens, case number 25.
Tiffany Woods for the people.
Charlotte Stefan on behalf of Mr. Hudgens.
Tiffany Woods for the
William, will
people.
you please
Charlotte
unmute
Stefan
yourself
on
and
behalf of
state your
Mr.
name?
Hudgens.
Yes.
William, will you please
H.
unmute yourself and state your name?
William Hudgens.
Thank you.
H.
We're here
William Hudgens.
today for a pretrial. And
We're
we're
on-
here today
sorry.
for a pretrial motion to modify the
We're on-
bond conditions
sorry.
filed. Then a
Yes, Judge.
motion to
We are
modify
here for the
conditions
bond motion
filed.
that we filed.
Yes,
I don't
Judge.
think the
We are
pretrial
here for
is
the bond motion
scheduled
that we
for today.
filed.
I don't think the pretrial
But
is
we are here for the
is
bond
scheduled for
modification
today.
motion.
Thank you.
But we are here for the
May I
bond
proceed, Your Honor?
modification
May
motion.
proceed. Thank you.
Thanks, Judge.
May I proceed,
Your
Your
Honor,
May
I'm sure
proceed.
the court read our
Thanks, Judge.
motion. It's very
Your
short
Honor,
and to the
I'm sure
point.
the court read
My
our
client has
motion.
no
It's
prior
very short and to the
criminal
point.
history.
My client has no
The
prior
complaining witness
criminal
is his
history.
wife.
And
The
it is
complaining
her,
witness is his wife.
wish
And
that
it is
that
her
Mr. Hudgens be able to return to the marital home.
Mr. Hudgens
my
be able
client's
to
47
return
years old
to
with
the
absolutely
marital
no
home.
criminal history.
My client's
They've
47
been married
years
for
old
15
with
years,
absolutely no
and they have
criminal
4 young
history.
children
They've been
together.
married for 15 years, and they
Although
have 4 young children
the
together.
complainant
Made
although
a report
the
to the
complainant
police, made
with some
a
allegations.
report to the police.
Based on that report, there are no
with some allegations.
There's no corroborating evidence.
Based on
such
that
as
report,
injuries
there
or
are
witnesses.
no there's no
And
corroborating
so,
evidence such as
without
injuries or
trying the
witnesses.
case, we are
And
maintaining
so,
his innocence.
without
and think that
trying the
eventually
case,
the
we
truth
are
will come
maintaining
out.
his
But in
innocence.
the meantime,
and think that
we
eventually
think
the
that
truth will
he,
come out.
but in the meantime,
Is
we
we
think
think
that he
to have the right to return to
is
his home,
deserving to have
and,
the
as
right
Ms.
to
Hudgens
return
wants
to his
contact
home
with him,
and
to be able to have
as Ms.
contact
Hudgens
with
wants
her,
contact with him,
the court
for him
rules
to be able to
Michigan
have
Court Rule
contact with her.
6.106D.
The court rules,
Michigan Court Rule
states
6.106D. Those restrictions are
states
only when
that
necessary to
those
reasonably ensure the
restrictions
appearance
are
of the
only when
defendant, or
necessary
reasonably
to
ensure the
reasonably
safety
ensure
of the
the
public,
appearance of the defendant,
and based
or
on
reasonably
the
ensure the
things I just
safety of the
mentioned,
public.
I don't
and
think that
based
those
on
restrictions
the
are
things I just
necessary
mentioned,
to
I
assure
don't think
the
that
safety
those
of Ms.
restrictions are
Hudgens or the
necessary
rest of
to
the public.
assure
And I
the
believe
safety
she
of Ms.
is present
Hudgens
here
or the
on
rest
Zoom
of the
today, Your Honor.
public.
And I believe
Yes,
she is
present.
present here on Zoom today, Your Honor. And I believe she'd like to be
Yes,
heard if the
present.
court is willing to hear from her. And I believe she'd
All
like
right,
to be
one
heard if the
moment.
court is willing to
Ms.
hear from
Woods?
her.
Judge,
All right, one
of course, we would
moment.
allow the
Ms. Woods?
victim
Judge,
to speak to the
of
court.
course, we would
and
allow
I can
the
tell you that
victim
plea
to
offer would be
speak
a
to the
DV
court,
court in
and
this
I can tell you
case.
that the plea
Ms.
offer
Hudgens?
would be a DV court
Good
in
morning,
this
Your Honor.
case.
Good Ms. morning, Hudgens? please state your name for me.
Good morning, Your Honor. Rashida Hudgens.
Good morning, please
Thank
state
you.
your
What
name
would
for
you
me.
like
to say this morning?
Rashida Hudgens.
Thank you. What would you like to say
This
this
has
morning?
been a trying time on our lives. This has been a trying time on our lives. Be able to and yes, I desperately ask that he be able to access back home. As much as it's been hurting, it's more so hurting to see my kids want their dad. It's more so hurting to see my kids. They're used to waking up every day, going to bed every day with their dad. They're used to waking up every day. I don't care about how much work I miss. And yes, true. I don't care about how much work I miss itself, but more so my kids' mental. That's always asking where is he, my kids' why can't we be together? And always asking where is he, I honestly why can't we be together? I believe it shouldn't even went this far. I honestly want this whole case throughout. I believe it shouldn't even went this far. Reaching out on multiple ends, and I tell them all the same thing. On this case needs to be tossed out. It should never have went this far, and he needs to be home. Simply put, it should never have went this far, and he needs to be home.
Well,
Simply put.
The prosecutor's office decides whether cases continue once you make the call now. Decides whether cases continue once you make whether or not the case will continue. It's up to the prosecutor. And at this point in time, they're not willing to dismiss this case. And at this point in time, they're not willing to dismiss this case. Understanding that you have a request here to understanding that you have contact with you and return to the home. Have your husband have contact with you and return to the home. To the discretion of the court. Is that correct? Ms. Woods is leaving that to the discretion
Yes,
of the
Judge.
court. Is that correct, Ms. Woods?
Yes, Judge.
Defendant's bond is modified. Defendant's bond is modified to allow him to return home. To allow him to no-go to is lifted. Home. So the no-go to
Thank you, Your
is
Honor.
lifted. And the no contact
Thank you,
is
Your Honor.
lifted. To make it a no unwanted contact is lifted. Mr. Hudgens, to make it a no unwanted contact. Mr. Hudgens, what that means for you, sir, at any point in time she says that she does not want to have contact with you, at any point in time she says that she does not want to have contact with you, then you have to leave. Okay. Do you understand that?
Yes.
Okay.
That hearing had a little bit of everything. Judge Irene Washington presided over a bond modification request in the case of William Hudgens, and what could have been a straightforward procedural matter turned into a careful balancing act between legal conditions, family requests, and public safety, represented by counsel, had originally been under strict no-contact and no-go orders after a domestic incident involving his wife. His attorney argued that the restrictions were unnecessary, pointing out Hudgens' clean record, his age, and the fact that the complaining witness was his wife of 15 years with whom he shares 4 young children. Counsel stressed there was no corroborating evidence of injury and maintained Hudgens' innocence, but asked at minimum for the chance for him to return home and resume contact with his family. The most striking part of the hearing came when Mrs. Hudgens spoke directly to the court. She described the hardship the restrictions had caused, saying their children asked daily where their father was and that the family routine had been painfully disrupted. She openly said she wanted the case dismissed and her husband back home, calling it a situation that should never have gone this far. Judge Washington listened attentively, then clarified that the prosecutor controlled whether the case proceeded, not the court or the complainant. Still, the judge considered the request seriously. Ultimately, she modified Hudgens' bond to lift the no-go order on the marital home and changed the no-contact condition to no unwanted contact. She explained the practical meaning clearly. Hudgens could return home and resume contact, but if at any point his wife withdrew consent, he would have to leave immediately. Hudgens acknowledged this with a simple yes. The courtroom atmosphere was calm but weighty, reflecting the seriousness of balancing family wishes against the safeguards usually imposed in domestic cases. Hudgens was respectful, his wife was candid and emotional, and Judge Washington's demeanor was steady, firm on the law, clear about the prosecutor's role, but flexible enough to adapt bond conditions to the family's reality. It was a reminder that courtroom decisions don't just exist on paper. They ripple directly into homes and daily lives. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.